Hi, hello everybody from Hamburg, Germany. I'm Mona Frobe, Senior Associate at Taylor Wessing in the IT Law and Data Protection team of Axel von den Busche, also from Hamburg, equity partner here, and our other colleague from Berlin, equity partner Paul Vogt, also specialist. I think everybody knows them probably in data protection law and IT law. And we wanted to give you all an update on what's new on the standard contractual clauses, what is up in practice, what do you have to do when you have a data transfer from the EU outside into a third country, for example, into the US. How have the regulators reacted in the past 2 years since the Schrems II decision by the European Court of Justice? And what is up with the transfer impact assessment, the so-called TIA? Are there any new insights? And in particular, we from Taylor Wessing have developed a tool that hopefully helps you all to conduct this TIA and gives you some guidance on how to do the data mapping and which security measures to ensure. Before we start with the view on the authorities and with the data protection or transfer impact assessment tool from Taylor Wessing, I will just give you a brief insight where we're coming from and what is the background of what we're talking about. And that is, everything started from July 2020 with the court decision by the European Court of Justice called Schrems II decision. I'm sure everybody is aware. The European Court of Justice held in its decision that any third country transfers, or basically the transfers to the US from the EU, cannot be based on the so-called privacy shield anymore. It held that the privacy shield did not protect the personal data of the data subjects enough, for example, for any possible data access by public authorities in the US, and further held that this would mean that data subjects do not have an adequate level of data protection as, for example, in the EU, and therefore further safeguards would have to be implemented. The decision created high excitement here in Germany and in all over Europe, actually, because everybody first thought, okay, we cannot ever transfer any personal data to the US anymore. But if you take a closer look at the decision, already the European Court of Justice held that, yes, the privacy shields became invalid. However, you could still base transfers to third countries, also into the US, generally on the standard contractual clauses in place back then. It further held that you would have to undergo further requirements before you take such a transfer of personal data. That means that you have to look at the individual case, whether according to the local laws, you would need further security measures in order to secure and protect the personal data in the local jurisdiction, for example, of your processor. This means that although the privacy shield was invalid, still any transfer of personal data could happen. However, the judgment did not really say in much detail how this transfer impact assessment and how this assessment in the individual case should be conducted. Therefore, soon after, the European Data Protection Board published in November 2020 their recommendations on how to conduct data mapping and security measures and how to implement security measures in order to secure personal data in a transfer to third countries. This so-called 6-step plan that the European Data Protection Board recommended will be introduced to you in more detail by Paul later. This is just for you to know that already in November 2020, before the new SECs became in place, we have a big structure of how to go through what to do before you do a transfer of personal data to third countries. As a follow-up, in June 2021, the European Commission implemented the new standard contractual clauses, which in their clauses 14 and 15 now also newly introduced the transfer impact assessment. So the key component of the new SECs is what the European Court of Justice most recently already decided would need to be done by any controller or processor that transfers personal data outside of the EU into a third country. Since July 2020, a lot has happened. Like I said before, it was a big excitement when the judgment came out. A lot of people thought they had to immediately stop any kind of data transfers to the US or to other third countries. Within the last 2 years, authorities next to the European Data Protection Board have provided various recommendations and requirements on what to do with any kind of third country transfer. And also we and Paul and Axel have experienced what it means in practice to undergo this data mapping and transfer tests and impact assessment. We would like to share our experience and the views of the authorities with you today. So before we come to the TIA tool created by Taylor Wessing, I would like to hand over to Axel, who will give you more insights on the recent developments by the authorities and the most recent case law. And if you have any questions in between, feel free to ask the questions in the questions field, and we will interrupt the speakers and then they can answer them directly.
Thank you very much, Mona. And hello, everybody. Good morning, in particular to the US. I hope everyone is well and excited to learn what's happened in our topic, Schrems 2. As you probably recall, Paul and I, in particular, we had a series of webinars last year, and we promised to keep you updated. Now, after approximately half a year, quite a few things happened, and it's time for a kind of fresh up where we stand, what happens with the authorities, are there any fines, are there any new guidelines, and what is the best practice at the moment. That's the whole idea. I start in the slide, as you can see, with this hot potato, and that only means, as you all know, this is really a complicated issue. And when the court came out in 2020, the judge said, actually, whoa, this is a very easy case. It's all written in the law. So I more or less what is in Schrems 2 is transformation of existing law. The judge said there was no need to be creative. Anyway, now he threw the issue into the laps of the authorities, and the authorities said, oh my God, this is really quite difficult. The last 20 years, somehow I accepted all these transfers, and now we are asked to stop these transfers, or let's say to kind of not really stop, but to review and screen very thoroughly and to see if these transfers are compatible with foreign surveillance laws. So that's a new thing, and the authorities in the beginning, they were quite loud, actually. You all know this, you all remember that. And they said, well, in the end, it's not our piece of cake. And they handed over the hot potato to the data exporters in the EU and in the EEA. And the data exporters, they said, oh my God, now we do data mapping and we kind of reorganize our transfers. And the hot potato goes to the data importer in the so-called third countries. And now this hot potato is jumping back and forth. Both data exporters and data importers together have to work on what we call transfer impact assessment, where Paul will provide a deep dive in a second. That's where we stand. And now, what is the stance of the authorities? As you probably also remember, in the beginning, the first wave was triggered by whistleblowers, activists, employees, consumers who went to the authorities and they said, authority, do something. There's this new judgment out and my personal rights are infringed because my data is traveling, for example, to the US, and there my data is not safe and my rights are undermined by surveillance laws, do something. So the authorities, they went out, and we had been part of debates with the authorities for our clients in that first wave. But that was purely reactive. And then the authorities, they changed the attitude after they kind of digested the court decision that was by November 2020, when the European Data Protection Board recommendation came out. And then they started to reach out to companies. In the beginning in 2020, still more or less in an informal way, like asking, hey guys, what are you doing? How you work with Schrems 2? Are you able to kind of web this into your day-to-day data transfer processings, yes or no? And we had been, we witnessed some of those, let's say, informal proceedings, still very burdensome, because our clients, they had to provide a data mapping. And yes, you will receive a copy of the slides after the webinar, no worries. Nadine, thanks for asking. And but there were no fines out. And then after a year, in 2021, actually, the authorities, they went a step further. They made something what I want to call a big due diligence. They went out with so-called questionnaires. Not all of the authorities, but the authorities who participated, they are on the slide there. It was, so each of the German Bundesländer who participated, they picked out approximately 50 companies, like that was a kind of lottery. And they just ask, this is, Schrems 2 is up, and the EDPB had provided recommendations, and even new standard contractual clauses are out. Can you please tell us how you work with that? These proceedings had been, like, in some of the German Bundesländer, still informal, just a question. In others, it was already combined with a formal proceeding in a way that these questionnaires had been hearing letters. And everyone who received such a letter really needed to get the ducks in the row in order to look good vis-a-vis the authorities. However, by now, there are no fines out. And by now, you would think it's nearly 2 years from Schrems 2. And if you take that Schrems 2 decision seriously, which actually now is embedded in the standard contractual clauses in clause 14 and clause 15. If you work with standard contractual clauses, please be aware, this is the heart of the SCC. This is Schrems 2 sitting inside. More or less, they haven't stopped any transfers. There is hardly any court proceeding there. So the authorities are still in a kind of learning phase. However, and that's what we learned from the authorities, they say, we want to see, if they reach out to companies, we want to see what you have done for compliance, brackets, although we know it's a mission impossible. So this is a little bit the situation where we are. Everyone knows it's super complex. The authorities not yet had stopped the data transfers, what they could have. So the world is still turning around in the data protection transfer world, but the risk is still there. So next steps, how to behave, what is to expected. And I think it wouldn't be advisable at this stage to think, oh, super, 2 years had been passed on. Obviously, the authorities in Germany and Europe, they have a big bark and a small bite. Now I forget all about that. We have to see this really long term, because you have to imagine how long data transfers outside of the EU had been existing. Like the last 20, 30 years, we have these data transfers already under the very, very similar law like the GDPR. So the predecessor, as you know, was the Data Protection Directive, still very similar law. So in theory, everyone should have taken account what Schrems 2 says for almost 2 decades, and the authorities too, but they didn't. So the change in, let's say, data protection infrastructure really takes time. I assume that's a kind of 10 years period from Schrems 2 decision in 2020 onwards. And the authorities, thankfully, they are aware about that. So there's no deadline out, but I come to one very important deadline in a second. There's no particular deadline out, but the authorities, they say, we want that you are active, we want that you do your data mapping in particular, and we want that you do proper transfer impact assessments. Each of the, you need to know what's going on in your company and where your data is traveling to. And you have to make sure that wherever the data travels to, the data is safe. Because as you know, as a general principle, the GDPR is super exterritorial, and that creates all the problems. The law is sitting on the personal data, and when the personal data goes abroad, the law, the GDPR, comes with this, with the personal data, and there you have the potential clash where the high standard of the GDPR often is not compatible with the surveillance laws of the data importing countries. And this is now actually the nucleus of the debate. The authorities realized when they dive deeper and in the proceedings where we represent our clients, the authorities suddenly had been aware, at the first sight, we have our recommendations, like 6 steps. Paul will describe them later in more detail. But in the end, you come to a point where there's really the key question: is the foreign surveillance laws like FISA 702, AO 12333, is this the executive order in this very matter for this very data importer, the situation, is this compliant with the GDPR, yes or no? And in order to be able to correspond to that key questions, the authorities, in the end, they need to assess the foreign laws, which they have, of course, no clue about. And often they don't even speak the language, like Chinese, Russian, English, like this. So suddenly, the authorities are aware about one really crucial point, that it's not so easy to enforce this, at least if they come to a situation where a company, where a data exporter has done its homework. So if everything looks neat and clean, just imagine you have like 200, 300 data transfers, and you have done your data mapping, and you have done your TIAs, the transfer impact assessments, and you even make an assessment at the site of the data importer, like, very simple question, does FISA 702 applies for your company, yes or no? Had there been any requests so far to that company from a US government, yes or no? Sounds quite simple. And we can come to a situation where you, as a data exporter and data importer, the two parties, they say, that's as a result of their assessment, they say, no problem. Yeah, we send out the personal data. We have several safeguards for that. FISA 702 does not apply in that situation, full stop. And now the authority comes, and what can they do? They say, well, I don't really, do I believe you? Yes or no? But if they say no, then you can say, okay, authority, please come. give me something like an official order, which I can fight against at the court, theoretically, and that's where the authority is refraining from at the moment, theoretically, say they can send out prohibition orders to stop the transfer. You go to court, and then the authority is obliged to provide evidence and proof that in this very particular data transfer situation, US surveillance, I take now the USA as example as a data importer, US surveillance laws are infringing the GDPR and are not in compliance with clause 14 and clause 15 of the standard contractual clause. Really hard to assess for everyone, for you, for us, for the authorities. And in order to make that, let's say, easier, and this is the news I have today in particular, is what happened between the years. In 2021, 2022, the authorities issued guidelines and, let's say, help and assistance in that respect for this very question: what happens when the personal data where plus GDPR meets foreign surveillance laws? How can we really assess this properly? And there's one memorandum, we call it Vladek memorandum. This was triggered by the German authorities from the Berlin one, and they sent out a questionnaire to Professor Vladek, a US specialist on US surveillance laws. That's the one who was instructed actually by Facebook in the Schrems II proceeding. So he has been asked as an expert, and the authorities asked several questions like, what is the scope of 702, Pfizer 702? Do the authorities need to, let's say, explicitly knock on your door before they have access to data, or can they do this more secretly? All these questions. And Professor Vladek answered these questions. And the whole idea was, well, now we know better. And just for you as information, I have here on the slides some links, and we provided a German, an English translation of that, so you can have a read on your own. The interesting bit is, with that piece, which is mostly important for our US clients, because this is related to US law, the most interesting piece is, what is it, this memorandum? Is it now law, or is it an opinion? And there is another little document from the German data protection authorities where they explain their standpoint to that, what they call memorandum of Professor Vladek. And this is that they said, oh, well, I know it's, they say, first of all, this is the opinion of Professor Vladek. So on the one hand, they say, it's not our opinion. So they say, well, this is just an analysis. On the other hand, they say, we will take this as a platform for further consideration when we look at data transfers. So it's a little bit open. What we can say in the end, this is an opinion of a specialist, and the German authorities might or might not take this into account when they do an assessment of transfer impact assessments they have under review. So that means one should have a look, one should be prepared that authorities take this as their starting point. But in the end, it's still an opinion. One still can say, well, I disagree. I think it's not right, and take another expert on board. Really very hard in the end to find a kind of, a final solution on that. The good news is that in the worst case, if you really want to escalate things, if you have a data transfer, which is really very important, you don't want to give up, and you escalate that to a court proceeding, and you say, no, I think US surveillance laws working differently. To have that in a court, a German authority which needs to apply US surveillance laws and to argue around that, they would need to ask Professor Vladek to step in or something like this. Very expensive. I hardly can imagine how that will work out in practice. We will see 1-2 court cases, but not too many, because it ends up in a complexity our authorities will not really be able to tackle. I think before we see lots of court cases here, we see a Privacy Shield 3 or 2, because the first one was Safe Harbor actually. Then we have another document from the
Axel, before you go over to other countries, I think we have a question that's still related to the US from Christian Drexler.
Yeah, this is of course a typical. The Google Analytics case is one of the key cases here, because it contains a data transfer to the US. And we personally have 2 matters pending in front of one authority, where the authority says, you shouldn't do that. You shouldn't use Google Analytics because of that transfers. And we are arguing that the so-called exceptional clause applies here. That's Article 49 of the GDPR. Where you can base your transfer on consent. And we say, well, although it's kind of mass consent, that should work. Whereas the authorities already, and the European Data Protection Board, they already said, we don't believe that you can, as a kind of alternative solution, alternative to standard contractual clauses, you cannot use consent as an exception under Article 49. A very, very important question, which is still open. Yeah, but let me go through that questions. Sorry, transferred. Let alone sensitive personal data. Sensitive personal data really there you need as a justification consent anyhow. That makes it even more complex. But that's an open issue. Totally open issue with Google Analytics and others, and we see where this goes. One last bit here. 2 things actually. The other document I would like to draw your attention to is also from the European Data Protection Board, and they did the same like the German authorities on the US. They did for Russia, China, and India, and guess what? The result is all very complex too. And for those who want to have a little deep dive, what the authorities are thinking about Schrems 2 and actually also cookies, I recommend this little video we have here on top. Some of you might have witnessed the session already. That was with one of our leading regulators, Professor Kugelmann from one German Bundesland, who explained how the authorities in 2020 will work, what is their standpoint. And he actually is the one who said this bottom line, we want to see what you have done for compliance. That was his main thing. So you need to look good. This is the basic message here. Last bit, and then I hand over to Paul for the transfer impact assessment tool, the core of the core. There is one hidden deadline I would like to draw your attention to, and this is the 27th of December 2022, because by December 26 this year, all existing old standard contractual clauses need to be replaced by the new SCC, which are now in place. And in the new SCC, as I explained, in clause 14 and 15, you see the Schrems 2 judgment. So so it's embedded in the SCC, and if you successfully would like to replace your old standard contractual clause, you must somehow also get along with these clause 14 and 15, which means you have to do a transfer impact assessment properly in order to get that installed. So this is maybe a little deadline, because after that, from the 27th of December 2022 onwards, the authorities can easily say, well, I assume you have done your homework properly. There's one written deadline. This is the one I was just mentioning to, and I want to see all your standard contractual clauses. Please provide a copy. So that's a kind of deadline we see here. Okay, now I hand over to Paul for the transfer impact assessment bit in our tool. Paul, please.
Thanks, Axel. Yeah, as you and Mona already mentioned, the transfer impact assessment is certainly one of the key parts of all cross-border data transfers now. And it was basically a gift brought to us by the European Court of Justice about 2 years ago, when the European Court of Justice said, if you do transfer personal data to countries outside the European Union, the European Economic Area, in particular to countries that are not regarded as safe, adequate third countries, you, dear data exporter, will have an individual assessment for each transfer that you're doing relating to the specific country the data is transferred to, regarding the specific importer, regarding the specific data subjects, the specific industry we're speaking about. So basically what the European Court of Justice said, it's not sufficient to look at just countries, as we frequently tend to do, but rather than that, if we look at the US, it may be different if you send data to the US, if you're a lawyer and send it to another lawyer, than if you're a software company and send it to another software company. So even the same country may come to different results. Quite broad, quite complex requirements that are difficult to deal with in practice. And so thankfully, the European Data Protection Board, so the conglomerate of all European data protection authorities, they came up with some guidance on how to do their respective transfer impact assessments. And this guidance, with some amendments, though, has also been included, as Axel already mentioned, into the standard contractual clauses. So before signing the new standard contractual clauses, both the data importer outside the EU and the data exporter will have to warrant that they have conducted a transfer impact assessment, and they have no reason to believe that the law applicable to the data importer will prevent them in any way from actually fulfilling the standard contractual clauses. So it's no longer a requirement that just derives from the European Court of Justice decision and the Data Protection Authority's guidance, but it directly derives from the contract that you're concluding as well. These transfer impact assessments will have to be conducted by the European exporters or even by the non-European exporters if you're a company based outside the European Union, but where the GDPR applies to you. So what do you have to do from a legal perspective? In a first step, you have to do some kind of data mapping, know your transfers. You have to get an understanding what kind of data are you actually sending to whom on what contractual basis. And that sounds like an easy task, but we have been assisting in transfer impact assessment projects for roughly 1.5 years now. And what we have seen is that this is quite a complex question. And finding out what kind of data transfers you have in place and based on what contract is not an easy task. And very often companies are struggling because they may not have the contract management processes in place as you would hope for. So actually getting this first information is quite difficult. But once you have that, you have to take a look at what specific safeguard has been agreed upon, the old standard contractual clauses. Frequently, for example, you will then have to switch to the new ones. You will, and this is the core part of the transfer impact assessment, you will have to do an assessment of the law applicable in the third country. Super complex, very difficult. For the US, FISA 702, the European Court of Justice did a lot of the work already, but for many other countries, it is quite difficult to actually assess that in practice. And to be honest, it will be the rare exception to come to the conclusion that you have a third country that is outside the European Union and is not considered adequate by the European Commission, and you still come to the conclusion that it's 100% perfectly fine and in line with European interpretation. That will be rather the exception than the rule. So if you come to the conclusion in this step 3 that the country of the importer is not in line with European standards, or maybe you did not even do this analysis properly because it is too burdensome, then you will have to jump directly to step 4. Identify and adopt supplementary measures, and the EDPB recommends some, like, for example, encryption. If the data is encrypted in a way that the data importer cannot actually read it, then you would not have an issue. Or if the data is pseudonymized, the same way that the data importer can actually not really do anything with the data, then you would assume the NSA can't do anything with the data neither. So that would be fine as well. There are a few other safeguards mentioned, though they are considered by the authorities to have lower relevance. So doing this transfer impact assessment from a legal perspective is quite difficult and burdensome, and it's difficult to weigh the risk, because on the one hand you do want to do the transfers, but on the other hand you don't want to have too much risk. So basically you have to test the waters. You have to use the gray areas that exist in order to still keep on doing what you want to do, but without major compliance risks. So quite difficult already, but the legal part is really not everything that is of relevance here. Actually, what we're seeing is that the organizational work in doing this transfer impact assessment is much, much bigger than the actual legal work. Why is that? Basically, you won't be able to answer the questions in step 3 and step 4 on your own, but you will have, as a data exporter, you will have to ask for assistance of the data importer. So basically, you have to draft a questionnaire, send that to the data importers, and very easily that will be a few dozens, or maybe a few hundreds, and ask for assistance and ask for specific questions. And you can imagine that is quite a lot of work. So you have to send out these emails, let's say a couple of dozen emails. You have to document those emails that you have sent out in a document management system, because otherwise you won't be able to fulfill your accountability requirements from GDPR. Then separately, you will need to have a project management tool or project management operation in place in order to ensure that you follow up with the vendors if they have not properly responded in the deadline that you have set to them. And you have to follow up a second time. And then some of the vendors may come back with follow-up questions. You will have to respond to them. Again, document all that in the document management system and in the project management tool. And once you got the finalized answers, very often you will understand the finalized answers, the finalized questionnaire is not actually the final answer, but you will again have follow-up questions. Some of the answers may not be conclusive. And again, you have to follow up, you have to document, you have to include it into the project management tool. So what we're seeing is basically 80% of the work in those transfer impact assessment projects is not so much the legal part, but it's actually the organizational part.
Can we go back to the legal part for the question
Sure.
by Wyatt Roberts?
Yes, Wyatt.
Just quickly, he has a question. When do you need a TIA for a processor to controller transfer?
So the processor to controller transfer, as far as I remember, you only have to do the TIA part when the processor in the EU collects data on behalf of the non-European controller. Yeah, so it's not the standard scenario, but only if there's new data that is collected in the EU. If it's just, for example, US data, but you have a European processor, then the TIA, from the top of my head, is not required. Next, another one, or can I proceed?
I think
This.
Axel is already typing, so maybe proceed.
Okay, all right. Then maybe I can quickly answer this one. Is there guidance on how to respond to TIAs for companies that transfer data to the US and may be subject to FISA, but the likelihood of such a request is low? Yeah, so this is not included in the, well, not really included in the EDPB recommendations, but at least from the standard contractual clauses, this is certainly a factor that can you take into account. The standard contractual clauses says if you have documented and reasonable understanding that there won't be any access requests, and there haven't been any access requests in the past, this can be taken into account when doing the transfer impact assessment and assessing the law of the importer country. Okay, that was the legalese part and the organizational part. So what have we done? We have in these projects that are very, very burdensome, take a lot of time, we have seen that quite a lot of the work that is to be done can be automated in a certain fashion. And this is what we try to do with our transfer impact assessment tool. Basically, what we're doing is you include all the information on the data importers that you have. So you just upload an Excel sheet with all the information, and they will all receive an automated link to a respective questionnaire that they are asked to fill out. And if they don't respond to it, they will receive a reminder. And if they don't respond to it, they will receive another reminder. Yeah. So everything is managed automatically via the tool without you having to take any actions. We have a few example slides on how our questionnaire looks like. It's okay if you can't read it in detail. It's just to give you an understanding. Basically, on the left-hand side, we have questions that are asked and certain options that can be chosen by the data importers. And on the right-hand side, we have explanations on what these questions mean and what answers we're actually looking for from the data importer to guide them. Because what we see in the projects quite recently is that even questions that seem quite straightforward, where you would think it's an easy answer, do you process personal data, yes or no, there are often issues because the data importer doesn't really know what personal data means. So we guide them, and they have the possibility to ask questions. You see here the letter in the right lower right side via the tool, and you or the user of the tool can communicate with the vendors via the tool and follow up on any questions. Once the vendor has completed the entire questionnaire, the tool will automatically give you a pre-result and will tell you, for example, in this example, this is a high risk, but it's borderline medium risk because, I don't know, it was US and Pfizer 702 applies, but some security measures have been taken, but not sufficient. And you have this pre-result, and you see all the answers that have been provided, and you can follow up. You see the links or the buttons. You can follow up to each specific question and ask the vendor if you have follow-up questions, or you can even change the answer and the entire result. So like in the end here, this is a finalized result. We have said it's rather a medium risk than a high risk. For certain reasons, can always be the case that you have individual factors that have to be taken into account. And it gives you an explanation. What does medium risk even mean? And it shows you how the tool came to the conclusion. So it will give you an information about the positive factors that have been taken into account and the negative ones. And you can basically get this information for all your vendors. The tool reports on that in a very easy fashion. So you see how many transfer impact assessments have been concluded and with what result. You have further reporting, for example, on how many transfer impact assessments are still open, how many emails have been sent and are not answered. You can see where the data importers stand when filling out the respective questionnaires. So maybe whether they have only filled out 50% of the questionnaires or 70%, so you can follow up with them and see whether they have any issue. And everything is neatly documented all in the tool, including the questions raised and answered and the finalized transfer impact assessments and the ongoing transfer impact assessments. So you don't need several tools to deal with the process, but everything is in one tool, which makes the process much, much easier. Even if you're not interested in the tool itself and rather want to do it manually, the tool and how we have set up the tool may give you some ideas or indications on how to run the transfer impact assessment process, because it basically includes the learnings both on a legal perspective, but also on an organizational perspective that we have made in these various transfer impact assessment projects. So if you're interested in either the tool or transfer impact assessments in general, please feel free to reach out, and we can also give you access to a demo account so you can take a look at the tool. So much with respect to transfer impact assessments. Mona, what do companies need to do now urgently in order to get ahead to deal with the respective requirements?
Well, first of all, they need to start. It's been 2 years since the Schrems II decision and 1 year since the SECs have become effective. And we highly recommend to look internally for any kind of data transfers to third countries. Make your data mapping, start maybe with a game plan, how you want to proceed, go from different internal regions, for example, HR or marketing, go from there. So you will see it will be a long process. If you are a bigger company, you will have lots of data flows into third countries. So you need a long breath, as we say here in Germany, and the most important part is that you start the process, that you do the transfer impact assessment for the different data flows. The most important thing always in data protection, do your documentation right as well. Constantly reevaluate what you implemented as security measures. No one expects it to be done by tomorrow, but authorities might come and knock on your door, and then they will want to see what you're doing and that you're doing something. And a quick win would be if you switch to the new SECs now, like Axel already pointed out, until the end of December this year, you will have to replace all existing standard contractual clauses that have not been from June 2021 with the new ones. And thus you will have to check all of your existing contract and yeah, apply the new SECs. The sooner, the better. The year will be over sooner than later and faster than you can see. I think we have 2 more questions. One has already been answered by Axel, but maybe we can answer Nadine's question. Do you recommend signing the entire SEC document with all clauses or sign a supplementary agreement stating that the old SECs don't apply anymore and the new ones do, and include a table with the choice you have made?
Yeah, maybe I take this one quickly. I think both is feasible. So you can either, various options. You can take the whole SEC with the 4 modules and just sign it, or you can basically sort out the specific module that you need and just sign this module. Or we believe it is also possible to just have a 1-pager referring to the specific SEC document and just making the specific choices. We do see that from time to time. Some clients refer that, and we believe that is also defensible to do that this way. So a few options basically, and actually a few clients have issues with signing like a 30-40 page document because it very easily gets very lengthy, and it would certainly be an option as well to just refer to the document and make the respective choices as you have proposed, Nadine.
Okay, if there are no further questions, I say thank you to all the speakers and everyone listening and watching, and I hope you all have a nice day and see you next time.
Thanks for joining.
Bye-bye. Thank you.